Good morning. Just checking if this is working.
Can you hear me?
Try again.
1, 2, 1, 2. Testing 1, 2, 1, 2. 1, 2, 1, 2. What? Testing 1, 2, 3, 4. Me? Hi. I'll go see if I have, but I don't see me on the video. So do you see me on the video? I don't see anybody. I don't see you either. Two. Testing 1, 2, 3. Testing 1, 2, 3, 4. Testing 1, 2, 3, 4. The speaker volumes are?
Testing, 1, 2, 3, 4. Okay.
Hear you twice. Where is the volume on this computer? Yeah. Can you hear me now?
Yeah. Whatever you did.
2, 3, 4. Okay, so you use these. Did you reach out to Jeff? Is he? Good morning, Peter. Can you hear us?
I can. Who's that? Mark?
That's Mark. Tom should also be on.
Yes. Hi,
Morning.
Tom.
Good morning, Peter. Good morning, Jeff.
Oh, Jeff, I see you're on. Excellent.
Can everybody hear me okay? Mark, can you hear me?
I can.
Okay, perfect.
Good morning,
I always
everyone.
say like the Verizon commercial. Can you hear me now? And everybody's screaming and saying no.
Yes. You guys will have to forgive me for not having a tie on. I'm currently not in my house. I had a flood last week and the insurance contractors kicked us out for a few days. So I'm without a tie.
I thought you were going to say it's some Canadian holiday that you didn't need to wear one today, and then we would have said, well, then we honor you. You know.
Yeah, it was unfortunate flood on our third floor bathroom that affected all the other floors down to the basement. So it's a bit of a disaster. So we're just working through it.
Sorry.
At least it's not frozen.
Right, exactly.
Catherine Mackley.
Morning, Karen. Can you hear me?
Yes.
Okay, thanks. I just wanted to test mine because I was on earlier and then I had to go off and then now I'm back.
Oh, okay.
Mr. Court Reporter, do you need to do a sound check?
Morning, Your Honor. That was not coming through clear.
Mr. Court Reporter, how's the sound?
The sound is okay.
Okay.
That's better.
We can hear you
Um,
now.
thank you. If we can go on the record then, please.
We are on the record, Your Honor. Thank you very much.
Thank you. Good morning, everyone. We are on the record in case number 9661, which is captioned in the matter of the complaint of the staff of the Public Service Commission against Statewise Energy Maryland, LLC. We'll start with appearances. Counsel for staff.
Good morning, Your Honor. Peter Wilson on behalf of the technical staff of the Maryland Public Service Commission. With me as co-counsel is Catherine McGurlin. In addition, staff witnesses Karen Robinson and Kevin Mosier are in attendance.
Okay, good morning.
Well,
Ms. Moriarty, did you want to correct the record on your name?
Peter, I didn't get the last name you said. You faded out.
Good morning, Your Honor, and thank you, Peter, for the introduction. My name has been changed recently. Sorry for the extra notice, but so it's Catherine, Katharine Moriarty, Moriarty. Thank you.
And Dave, I believe the last name that I said was Kevin Mosier.
Do you need that spelling?
Mosier.
Thank you.
Tom, you go, Tom, so we're not talking over.
Okay.
Thank you all.
Tom Puckner, Phillips Lytle for Statewise Energy Maryland, LLC. I have with me Mark Goldberg, MarcGoldberg, and Jeff Donnelly is the witness for the company.
Morning, Your Honor.
Good morning. And OPC?
Good morning, Your Honor. Jacob Alexander on behalf of the Maryland Office of People's Counsel. It is just me this morning and we have no witnesses.
Okay, good morning. All right. This is a complaint brought by staff, so staff should probably proceed first. Mr. Wilson?
Yes, Your Honor. I believe staff has testimony to enter into the record, as well as another exhibit. I believe, as we've done in the past, the parties will agree to proceed with entering the evidence as a stipulation. So if I could start by marking some testimony. If we could mark for identification staff exhibit 1, that would be the direct testimony of Karen Robinson. That would be the corrected or replacement version that was filed on August 10th, 2021, mail log 236559, docket number 26. Along with that, we'd ask to be marked as for identification staff exhibit 1C, and that was the confidential exhibits to the direct testimony of Karen Robinson. Those were filed on August 6th, 2021 as mail log 236496, and that's marked on the docket, entered into the docket as number 23. Marked for identification Staff Exhibit 2, which is the direct testimony and exhibits of Kevin Mosier, Mosier, and Staff Exhibit 2C, which is his confidential exhibit to his direct testimony. Those were filed on August 6, 2021, mail log 236496. That's also docketed at number 23. And then marked for identification, Staff Exhibit 3, which is the testimony in support of the settlement of Kevin Mosier, and that was filed on November 11th, 2021, mail log 237840, docket number 40. And finally, if there are no objections from other counsel, we would mark for identification as Joint Exhibit 1, the joint petition for approval and adoption of the settlement, which includes Exhibit 1 to that joint petition, which is the executed settlement agreement. And that was filed November 3rd, 2021, as mail log 237707, and that's on the docket as number 37.
Okay.
So
with respect to that one, my preference is not to mark the joint petition itself, but just to mark the settlement agreement.
that's satisfactory with staff, Your Honor.
Okay, and let's just call that staff 4 instead of having a joint exhibit.
Okay. Well, with that then, Your Honor, I would move in to evidence Staff Exhibit 1, Staff Exhibit 1C, Staff Exhibit 2, Staff Exhibit 2C, Staff Exhibit 3, and what is now Staff Exhibit 4.
Okay, by stipulation, those will be entered into the record.
Thank you, Your Honor. I can make my witnesses available to you now, or we can, as whatever your preference is, if you want to hear from them after the other parties have had an opportunity to enter their testimony.
Why don't we go ahead and enter all the exhibits since they're being entered by stipulation, and then we'll come back to your witnesses.
Very good.
So, counsel for Statewise.
Good morning, Your Honor. Mark Goldberg on behalf of Statewise. Just for housekeeping purposes, we have no objection to the introduction of the exhibits marked by Mr. Wilson. And prior to the conference, we spoke and conferred and agreed that there was no objections to the direct testimony. I know that there's certain aspects of the confidentiality agreement, or at least confidentiality of some of the documents, and we have no objection to that. So just
Okay, yeah, you would not really be in a position to object given the settlement agreement.
no, I understand. But I wanted to let Your Honor know we had no objection to the.
Okay, that's fine.
We would like to offer as Exhibit 1 the confidential direct testimony of Jeff Donnelly, submitted on September 17th, 2021. I'm just trying to check the docket number, Your Honor, for the purpose of the record. And I apologize for not having that in advance of today's testimony.
I have docket number 28.
And there's an ML number that's listed at the
37081.
And Your Honor, we also offer the testimony of Jeff Donnelly in support of settlement, submitted on November 22nd, 2021, docketed as docket number 42, mail log number 27936. That comprises of 7 pages inclusive of the cover page.
Okay, can we go back to Exhibit 1? Was that inclusive of Mr. Donnelly's exhibit? I believe it was Exhibit 1.
It was submitted, it was filed separately.
The exhibit was filed separately, Your Honor.
Okay, are you not?
No, we will offer the exhibit as well.
Okay. So, but you want 2 to be the settlement testimony?
Yes, so the direct testimony exhibit 1 with the exhibit 1A, and then the direct testimony in support of settlement as exhibit 2.
Okay, so Exhibit A, which is titled Complaint Files to Mr. Donnelly's direct testimony, will be marked as Exhibit 1A.
Thank you, Your Honor.
Is that all you have to mark?
Yes, Your Honor.
Okay. So statewise exhibits 1A, and 2 will be entered into the record. Mr. Oslander already indicated that OPC has no exhibits, so we are back to you, Mr. Wilson.
Well, Your Honor, we have available for your questioning what you indicated you wanted to speak with Ms. Robinson. So,
Well, you actually offered Mr. Mosier, and Mr. Mosier has now filed settlement testimony that's been entered into the record, so I'd like to talk to Mr. Mosier.
okay, well, that's fine. Well, then we will call Mr. Mosier to the stand for you, Your Honor, and make him turn him over, make him available for your questioning.
Mr. Mosier, can you turn your camera on, please? I would ask that everyone else remain on mute until you feel the need to speak, please. I'm trying to mute people here. Mr. Wilson?
I will call Mr. Mosier and see if there's a problem.
Okay.
I can hear you now, Peter.
Okay, Mr. Mosier, can you please turn on your camera?
Oh, I'm sorry.
Thank you. Can you please raise your right hand? Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Okay. Can you state and spell your name for the court reporter, please?
Kevin Mosier, KevinMosier.
Do you have the ability to
Kevin,
turn up?
I did get your sound, but can you lean in a little closer to the computer so your volume will come up a
Okay.
little bit?
Yeah, your volume is a little low.
Okay, is this better?
That is. Are you going to hold that the entire time?
I think I may need to.
Okay. All right, Mr. Court Reporter, you have the spelling, though?
I have everything, Your Honor. Thank you very much.
Okay. Mr. Mosier, do you have in front of you what's been entered into the record as Staff Exhibit 4, the settlement agreement?
Not in front of me, just give me 1 second. I'm sorry. I pulled up my testimony. I didn't pull up the settlement agreement, so it's taking me a minute to find this. Actually, Peter, would it be possible to email me a copy?
How are we doing on that request, Mr. Wilson?
I just sent it, Peter and Kevin.
Thank you.
Yeah, my apologies, Your Honor. I'm not sure I saved this.
Let me know when you have it up.
Okay. Okay, I have the settlement agreement up.
Okay. Section 3, paragraph C.
Yes.
One little I. SWE agrees to modify its electronic verification ETPV and/or third-party verification TPV, both hereinafter collectively TPV, to confirm that the customers received the agreement. So Statewise can continue to use a third-party verification where an independent third party calls the customer via telephone to verify the enrollment, correct?
Correct.
Or Statewise can use its I-signed electronic verification process, which does not involve an independent third party at all. Is that also correct?
Correct.
So Statewise modifies both processes to confirm that the customers received the agreement. What agreement?
But I believe that would be the contract.
Okay, do you know what comprises the contract?
I mean,
If you don't,
yeah, I don't know that I do. I mean, my answer would just be the contract, and obviously that's not really a helpful answer. But I'm not sure more details than that.
okay. Are you familiar with the fact that customers of Statewise could elect to sign on the Statewise sales representative's electronic device after reviewing the agreement on that device?
That is my understanding.
Okay. So do you know if the phrase receive the agreement refers to the customer's review of the electronic contract on the representative's device prior to enrollment, or whether it means receipt of their copy of the agreement at some time later?
I believe the latter, but I'm not entirely sure about that. I don't think I'd given that issue a lot of thought.
Okay. There is some reason, though, that it's important to staff for the eTPV transcript to be modified. Is that correct?
Well, I think we, just wanted to ensure that, we just wanted sort of a second layer to ensure that, if the customer signed the contract, there was some follow-up to make sure it was a mistake, I guess.
So do you know how Statewise is going to modify their TPV process to confirm that the customers received the agreement?
I do not.
Okay. Are you familiar with their eTPV transcript that they used to use?
I had seen some in the complaints.
Okay. And which aspect of staff's complaint is this particular provision of the settlement agreement intended to address? Do you know?
I don't know. That might have been, I think that might have been more on the side of our Consumer Affairs Division testimony. Mostly my testimony, I believe, was just focusing on what we thought may have been misrepresentations.
Indeed. Your testimony in this case, which has been entered into the record as Staff Exhibit 2, your direct, discussed misleading statements by door-to-door agents. Starting on page 3 of your direct, you testified that you discovered 31 of the complaints filed against Statewise included claims of misrepresentations. You did discuss on page 7 of your direct in unauthorized enrollment, and you listed 15 invalid enrollments. One of those was case 120346102. And if we look at that just as an example, the allegations in that complaint were, and this is a direct quote, "I was directed to contact you by the State AG Consumer Protection Division. I was contacted by a Statewise rep in September 19. Did not identify himself. Presented as being with BGE. Claimed I was being given a reimbursement by BGE. Signed me up for Statewise. Called and got it canceled on 9/17/19. Got another letter on 1/2 saying I'd signed up. Called and they said I signed up on 12/18. Never talked to anyone. They have canceled, but this is repeated fraud by this company. Tons of other testimonials about same practices when I searched them online." So my question to you, Mr. Mosier, is Statewise agreeing to confirm that the customer has received the agreement, that wouldn't address those allegations in that complaint, would it?
I don't believe so, no.
Okay. People can still be enrolled without their consent, say, if, for example, the ETPV is not completed by the customer, correct?
Yes.
Okay. Next, under section 3, paragraph C, 2i, Statewise or SWE agrees to continue to generate proper enrollment documentation to all customers and to redistribute proper enrollment documentation as of November 14, 2020 to all customers that filed complaints. Did you review the direct testimony of Jeff Donnelly, which has now been entered into the record as Statewise Exhibit 1?
I have.
Okay. Do you have that in front of you?
Give me 1
Mr.
minute.
Wilson. Mr. Wilson, are you with us? Did you not
I am
prepare
with-
your
I'm-
Did you not prepare your witness for today?
Yes, I did.
Okay. Does he have the direct
But-
testimony?
Your Honor, we were under the belief that you had no questions for him, which is because you would only ask for Ms. Robinson.
Okay. If he needs help getting the direct testimony of Mr. Donnelly, you'll help him. You'll email it to him.
I shouldn't take more than about 30 seconds.
I think Ms. Moriarty is more adept at that than I am.
Okay.
Yes, working on it. Just one moment, please.
Mr. Mosher, you're still very low. I need you to speak up or get closer to the microphone.
Okay, will do. Okay, I have the testimony in front of me.
Okay, I'm at page 20, line 20. Are you there?
Just 1 moment. Yes.
Okay, so Mr. Donnelly testified that for each and every case in this matter, Statewise provided enrollment documentation comprised of the following components. 1, a contract summary. 2, terms and conditions. 3, signature page. And 4, third-party verification, TPV, where applicable. Collectively, these materials constitute the total legal obligation that results from the parties' agreement. Mr. Mosier, isn't it staff's position that this enrollment documentation was insufficient and that a separate contract document is required?
I can't answer that. I'm not 100% sure.
Okay, so you don't know under section 3C 2i of the settlement agreement what is meant by proper enrollment documentation?
I do not.
What about the notice of cancellation? Do you know, are you familiar with that?
Not particularly.
Okay. Okay, next under section 3, paragraph D, 2i, SWE agrees that the 7 customers who filed Consumer Affairs Division, CAD, complaints, and any other customers who complained to SWE directly, internal complaints, in either case during the time period in the case, that the person who enrolled was not authorized, i.e. not the customer of record, will have their enrollments canceled, any early termination fee, ETF, waived, and re-rates will be processed. With respect to the 7 customers who filed Consumer Affairs Division complaints, haven't these 7 customers already had their enrollments canceled and their ETFs waived?
I'm not sure.
So you don't know also whether they were re-rated or not?
No, I do not.
Do you know what re-rated under the settlement means?
I believe it means, what it typically means is that the rates would be lowered to match those of the SOS rates.
With regard to paragraph G of the settlement, allegations of misrepresentation, which, as you said, was a primary focus of your testimony. At page 10 of your direct, you have that in front of you.
Just one second. Okay.
At page 10 of your testimony, you had recommended that Statewise be ordered to record all door-to-door sales. Quote,
Yes.
a number of the complaints involve allegations of serious misrepresentations by Statewise agents. A recording of these interactions would either show these allegations are accurate, in which case further action may be taken against Statewise, or it would show they were false, in which case they would provide Statewise a means of protecting itself from false allegations, end quote. Pursuant to the settlement, SWE is going to submit a compliance plan for staff approval, and according to Mr. Donnelly's settlement testimony, which has been entered into the record as Statewise Exhibit 2, that compliance plan has already been submitted. Have you reviewed that compliance plan?
I have not.
Do you know if staff has approved the compliance plan?
I do not.
So do you know what staff is looking for in that compliance plan?
Not off the top of my head, no.
Do you know what happens if staff doesn't find the compliance plan to be adequate to address the types of misrepresentations that were alleged in the complaints in this case?
In that way, in that instance, I would get together with Mr. Wilson and find out what he thought the proper method of the proper response was.
Okay, but again, you don't know. You don't have any thoughts on what should be in that plan to address your findings in your testimony.
Again, as I mentioned in my testimony and you just pointed out, I would like to see the door-to-door sales, recorded. But to be clear, I would like to have that as a regulation required for all door-to-door sales across all suppliers.
Okay.
But I don't know that, I don't know if that's feasible or.
So that's what you would be looking for in the compliance plan.
I would certainly like to see that, but I don't expect to.
Okay, well, what do you expect to see that would be acceptable, that would address the types of misrepresentations that were alleged in the complaints in this case?
Honestly, I'm not really sure. I mean, again, with, in looking at these various cases, this one and other cases, there's always allegations. Well, there's oftentimes allegations that, the door-to-door salesperson said something misleading or a misrepresentation. but there's virtually never any actual proof of this, which is why I made that recommendation. I think that would work. There's other things that we've recommended in the past that I don't know how successful they've been, and I'm not sure what would work.
Does a fine work?
I hope a fine is at least some incentive to be more cautious.
Do you know still in paragraph D, but now I'm at 3i, what SWE's health and safety plan is?
I do not.
Okay, thank you, Mr. Mosier. Mr. Wilson, that's all I have for Mr. Mosier.
Thank you, Your Honor. We'll call Ms. Robinson for your questioning of her at this time.
Thank you. Ms. Robinson. Is, you might still be muted.
Yes, I was.
Okay, can you please raise your right hand?
Mhm.
Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
Right. Do you have your direct testimony in front of you?
Yes.
Okay, I'm on page 10 at line 2. Let me know when you're there.
Okay. Is that line 2?
Yes.
Page 10. Yes, I'm here.
Okay. What I'm trying to understand is what CAD's final position is on what documents are required for a valid enrollment. You testified that providing a contract summary along with a signed TPV form, signature page not meeting COMAR or state law guidelines to include terms and conditions and blank cancellation form is not sufficient to meet state law and COMAR's contracting requirement. CEU, which is the Consumer Enforcement Unit, do I have that right?
Yes. Yes, Your Honor.
CEU review of the consumer complaints filed with CAD between May 1, 2019 and May 31, 2020 revealed that the required contract was not found in any of these cases, only the contract summary followed by a signature statement and terms and conditions. And then at page 14 of your testimony, line 8, are you there?
Yes.
You further testified that a notification was first provided to Statewise on May 29, 2020 under MPSC 420346829, advising Statewise of the defect in its contract practice, and that the contract summary followed by a signature page with terms and conditions could not be substituted for the required contract. Is it CAD's position that a separate contract document is required for a valid enrollment?
Yes.
That separate contract document may have as part of it terms and conditions, but there needs to be a separate document that is titled contract or agreement, correct?
Yes. Or it could say any variety of titles because different suppliers use different title, but as long as it meets the minimum requirement of a contract to include the pricing, the names, and things of that nature. We look for a separate document in addition to the terms and condition and the contract summary.
Okay. Is it also CAD's position that there needs to be a notice of cancellation with the date of the transaction and the date not earlier than the 3rd business day following the date of the transaction by which the buyer may give notice of cancellation filled in?
Yes, it should have the date on the contract notice along with the information how the person can contact the supplier. But yes, the customer should also receive the contract summary. Should also receive the cancellation notice, and the rescind statement is our position, should be near the signature line
Okay.
on the contract.
Just so we are completely clear then, the electronic documents need to include a contract summary, a contract that is signed, a notice of cancellation that has the date of the transaction and the date by which the consumer can cancel already filled in, and a third-party verification when a telephonic TPV is not used. Do I have that? All of the documents that are necessary?
It should. What we don't require the electronic third-party verification. That's optional. What we require, like you said, is the contract summary, the terms and condition, and the notice of cancellation, and did I say and the contract? I don't know if I already said that.
Okay. Is
But
it
the electronic third-party verification that's supplied to us, we look on it as supporting the enrollment, the same as the TPV recording. To CAD, it means it's similar, the same thing to the TPV is the recording, and the ETPV strip is basically the same, having the same information or asking the same questions.
what about receipt of signed documents? In other words, we talked about what CAD's position is as far as the documents that are required for a valid enrollment, but is it CAD's position that not only must there be those documents, but the copy of the signed contract must be received by the customer?
Yes,
What about
either
the
physically
sign?
or, Mhm.
I'm sorry, go ahead.
I said yes, either physically or electronically, if they agree to receive it electronically.
Okay, and do you know about the timing of that receipt?
Well, for the door-to-door, supposed to receive it at the end of the transaction, or either agree to receive it electronically, which is shortly thereafter, so that the rescind period can be met if the customer should decide to change their mind.
What about the ETPV? Now, I understand what you're saying, that you don't consider that required for the enrollment. You're looking at that later for the verification. But if there is an ETPV that the customer signs, should the customer also receive a copy of that?
Yes, in my opinion, they should. COMAR doesn't, address as far as the ETP, if they should receive it or not. But we do look for that to support the enrollment.
In your experience, has CAD ever compared the signatures on the signature page that Statewise provided you with the signatures on the ETPVs they've provided?
It's our position that we don't compare the signature, because we feel as though that's a court matter, for situations where a customer may indicate that it's not their signature. So we generally find the e-sign act, and we don't challenge any signatures on the contract or the ETP transcript.
Okay, so no CAD decisions in this case would have been based on the signature on the ETPV.
No, we don't have the authority to do that.
Okay. Thank you, Mr. Wilson. That's all the questions I have for Ms. Robinson.
Thank you, Your Honor. That would be all of our witnesses.
Okay. Mr. Goldberg, is Mr. Donnelly available at this time?
He is, Your Honor.
Okay. Mr. Donnelly,
Yes, Your Honor.
can you please raise your right hand? Do you swear or affirm under the penalties of perjury the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I do so swear.
Do you have the settlement agreement in front of you?
Yes, I do, Your Honor.
Okay, let's go back up to section 3, paragraph C.
Yes.
where SWE agrees to modify its electronic verification ETPV and or third-party verification TPV, both hereinafter collectively TPV, to confirm that the customer has received the agreement. Do you know what agreement we're talking about in that sentence?
Yes, Your Honor, it would be the completed signed electronic agreement that would have been sent to the customer prior to commencement of the TPV or ETPV.
So that would have been, let's see. Is that what Statewise considered the agreement? In other words, the contract summary, the terms and conditions, and not a separate contract document. Is that correct?
Statewise position is that what was produced for the customer was a completed contract in regards to COMAR regulations. We recognize staff's concern in relation to the specific details of the documents. We've made such changes when the issue was raised by staff in May of 2020. We've corrected the generation of the contract. That was the final PDF version that was produced for the customer. The actual sign-up process, the customer reviewed all of the details, the terms and conditions, as well as the rescission period.
Can I stop you right there?
Oh, sure.
That's not my recollection of your testimony. My recollection of your testimony is that Statewise continued to not understand CAD's interpretation that a separate contract document was required and continued to believe that its practice of having a contract summary, a document entitled Terms and Conditions, a signature page, and an ETPV, if applicable, constituted the entire agreement and was sufficient after May of 2020. Is that not correct? Because we can review your testimony.
Our position was that what we were generating was in compliance with COMAR, subsequent to consultation with staff, and we made requested recommendations. We took those into account and made such changes to the generation of the contract.
The generation of the contract. Can you point me to a document that's been entered into evidence that reflects a separate contract document that Statewise started using and when?
I can't point you to that, no.
Okay. So are you testifying that Statewise started to use a separate contract document at some point?
No, I'm just simply testifying in relation to the ongoing discussions with staff in relation to their concerns and how we went about addressing that and arriving at the settlement.
Okay. So if we go back to one little I in section 3, paragraph C, and Statewise is agreeing to modify its TPV process to confirm that the customers received the agreement. Please tell me what documents the customer is going to receive that Statewise is confirming.
Customers going forward will receive the contract summary, the contract details, the signature page, the terms and conditions, the cancellation notice.
You said the contract details?
That's correct, yes.
What's that mean?
The contract details, Your Honor, is essentially just a reiteration of what the contract summary is. The contract summary itself is supposed to be a one-page reference for the customer to be able to have all of the pertinent details of the contract terms before them. So the second page would essentially be reiterating those contract terms, including price, term, length, cancellation, and then accompanying with the terms and conditions and the cancellation notice.
What would the customer sign?
The customer signs the contract with the contract details that is accompanied by the contract terms and the cancellation notice.
Okay, but I can't see that contract? You can't show me that. That's nowhere in the record, right? Is that what you said?
I'm not aware, Your Honor.
Have you seen the contract?
I have seen the contracts that we generate. Yes. And majority of those would also be within the CAD complaints, Your Honor, as well.
Okay. I'm trying to understand what's going to change pursuant to the settlement agreement. Do you have your direct testimony in front of you?
I don't have the direct testimony, and oh yes, I have my reply testimony and the settlement testimony.
I'm sorry. That's what I mean. Your
Oh, okay.
testimony.
Okay. Yeah. Okay.
It was entered into the record as Statewise Exhibit 1.
Jeff, that's September 17th, 2021, when you submitted
Correct.
the testimony.
Yes, I have it in front of me.
Okay. At pages 18 to 20, you testified about your iSign platform.
Yes, Your Honor.
Am I correct that agents first obtained signatures through the iSign platform, resulting in a signature on the signature page that became part of the file prior to Statewise transmitting an ETPV via email if they were going to use an ETPV?
Sure. I think I have to break that up into two components because I think you might be mixing the two together as far as the steps that take place during the sales process. So,
okay, walk me through the steps.
Sure. So steps are the sales rep approaches the customer's door for the solicitation, identifies themselves, provides a business card, and then talks to the customer about the product offerings. The customer wishes to proceed. The sales representative will show the customer the contract terms, price, length, cancellation, and then would proceed to the contract terms page. On that page would have the contract terms that the customer has to scroll through completely. It'll also have the right to rescind language that's required to be present above the signature line. And then the customer, if they wish to proceed, would then sign the electronic document at that point. Upon completion of the electronic signature on the document, a PDF document is generated and emailed to the customer's email. At that point, then the verification process would start. So if they were to start a live TPV, one of the confirmation questions on the TPV would be that the customer had received a copy of the completed agreement. And then on the eTPV, a similar question would be asked. In this particular situation, staff recognized that the language for the confirmation on the eTPV and the live TPV could be modified slightly so that it was very clear that the question being asked was for the customer to confirm that they have received a copy of the completed agreement prior to commencing the remainder of the verification call, or eTPV. In that case, that would come up as one of the first questions.
Okay, so the signatures on the signature page that became part of your files in this case, that's the signature of the enrolled customer, correct?
Yes, Your Honor.
Okay. And then what you just said at page 20 of your testimony, line 5, you testified that immediately following completion of the touchless enrollment process, the sales representative leaves the premises and Statewise sends the customer an eTPV. And I believe you're correcting that today to say, well, I'm not sure if that's what used to happen, but what you're saying is under the settlement agreement, the order of things is not going to be the same. Immediately following the completion of the touchless enrollment process, what's going to happen first is the customer will receive an email with the completed agreement, whatever that is that we don't know, prior to the TPV process beginning.
Correct.
Is that okay? Do you have any idea the time frame between the email that the customer receives with the enrollment documents, the agreement, and an eTPV?
For the eTPV process, the IT systems program won't send the link to complete the eTPV to the customer unless the PDF email has already been sent and delivered to the customer.
Okay. And that's a change pursuant to the settlement agreement?
Correct.
How is Statewise going to confirm that the customer has received the agreement? Just through the ETPV process?
If the customer elects to complete the TPV with a live third-party agent, it would be the verbal question being asked. On the ETPV, it would be one of the first questions asked by the customer. And they would have to affirmatively acknowledge a yes that they have received it. Otherwise, the ETPV would be canceled and the enrollment would be declined on our end. It would not be submitted to the utility.
So you're going to change the order of the questions? Because it used to be the
That's
6th
right.
question.
That's correct, Your Honor. We're going to change the order of the questions, make the questions a little bit more definitive on what the ask is, and that way then, if the customer was to answer no in response to that question, the ETPV will be declined and the sale process will end at that point, and no enrollment will be submitted.
Okay. I wanted to clarify Statewise's position regarding its ETPV. Is it your position that your ETPV negates the possibility of any misrepresentation, or that the ETPV negates any misrepresentation because it essentially corrects it?
I wouldn't say that the ETPV standalone on its own resolves any potential allegations of misrepresentation. It's a combination of the questions, to your point on your second question. The combination of the questions on the ETPV may correct an understanding with the consumer, but the consumer also has an opportunity to negatively respond to that, which would decline the ETPV and cease the sale process, and there wouldn't be an enrollment submitted. So the combination of the questions of the ETPV with other steps that we've taken as part of the compliance plan, in our mind, provides a material level of consumer protection over and above what other suppliers are required to do within the industry under the current COMAR regulations.
But the ETPV can operate to negate an earlier misrepresentation by correcting it. Correcting the information that the customer heard.
Well, I wouldn't necessarily refer to it as correcting. If the customer answers yes to the question, then that's an affirmative response that there wasn't misrepresentation. If the customer negatively responds to the question, then that is an indication that there may have been misrepresentation. So the sale is declined and doesn't proceed.
Okay,
and
so
that,
it's
yeah.
your testimony there's never an occasion where there's a misrepresentation and the customer hears a question on an ETPV, now understands that they were told something that was wrong, but goes ahead anyway. That's not your position. That never happens.
It's not my position that customers complete the ETPV and don't subsequently file a complaint later on for whatever particular reason.
That's not my question. My
yeah.
question is, do you believe that there's ever times when a misrepresentation is made, but then the ETPV, because of its wording, takes care of the person is no longer misinformed because they hear a question and they realize that they were given misinformation, but now they understand what the contract is, and so they go forward. I just want to know if you think that is
I'm not aware of us ever receiving such a complaint in relation to that specific issue.
Okay, also not my question. Do you think that ever occurs? Is it at all a possibility, or do you not take the position? Let's put it that way. Do you not take the position that your ETPV can correct a misrepresentation?
I don't take that position.
Okay, thank you. All right, still under Section 3, Paragraph C of the settlement agreement. 2i, SWE agrees to continue to generate proper enrollment documentation to all customers and to redistribute proper enrollment documentation as of November 14, 2020 to all customers that filed complaints. So what's the significance of November 14, 2020?
That's the date in which we made the changes. We recognized what was brought to our attention by staff and their concerns, and in the course of dealing with the staff complaint, trying to be proactive and collaborative with staff, we recognized that this was a situation that needed to be addressed during the negotiation process with the complaint, so we made the change at that point. So we're not sitting and waiting per se to make such a change if and when the settlement agreement is approved.
Okay,
we
so-
recognize it's important to do it ahead of time.
Use of the phrase "to continue" and "redistribute" means that you intend under the settlement agreement to continue to use the whatever enrollment documentation you used as of November 14, 2020.
That's correct, Your Honor.
So if I see complaints filed after November 14, 2020, where there's no separate contract, then I can assume you don't intend to send a separate contract under the settlement agreement. Is that correct?
Sorry, can you just clarify that question again, Your Honor?
If I were to happen to see complaints filed after November 14, 2020, I guess to be fair, complaints for which you sent enrollment documentation after November 14. So customers you enrolled after November 14, 2020. So the complaints would obviously be after November 14, 2020 as well. If I see one of those where there's still not a separate contract, am I to assume then that under Section 3, Paragraph C, 2i, proper enrollment documentation would be what you sent in those instances? And not a separate contract?
I don't believe that you would see any complaints that would fall in that category because we had voluntarily ceased marketing already by that period. So any CAD complaints post-November would have been contracts, most likely contracts that are signed pre-November of 2020.
When did you cease marketing?
Don't recall the exact date. June 3rd, 2021. Sorry, I correct myself then, Your Honor. So just to if you could just repeat your question again, make sure that I fully understand. You're asking whether complaints that were submitted post-November from customers, they should have received completed contract documentation.
Which would include a separate contract document.
Yes, they should have received the separate contract document and the completed documentation that was corrected as a result of the staff bringing it to our attention.
Okay. Mr. Wilson.
Yes, Your Honor.
Do you know if there is in the record in this case a complaint for which the transaction occurred after November 14, 2020 that we could look at?
I believe there is, Your Honor. It was my understanding that the reason that the word continue is to generate proper enrollment is because this problem was already addressed by Statewise. But
right, and I'm trying to see how it was addressed, and no one can point me. He couldn't point me to that. He says it's not in the record. So maybe you can.
well, having one screen, it's difficult for me to go look for one.
Okay,
right
maybe
now.
Ms. Moriarty can help you with that.
I was going to suggest that, Your Honor.
Okay.
And maybe Ms. Robinson could confirm that the complaints we had as to that aspect of the violations took place earlier, and we didn't see those later on.
Yeah, I'm still going to have an issue. You have entered into an agreement that refers to something that's not defined and hasn't been produced. So it's
Oh, Your Honor, Catherine McErlane, or Moriarty on behalf of staff, sorry, getting used to the new name. Would you please repeat the time frame that you just said? It was buffering a bit, and I just want to make sure that I am pulling up the proper timings.
Okay, so the settlement agreement has the date of November 14, 2020. And the witness testified that that's the importance of that date is that's the date after which they corrected what staff's position was that their contracting process was deficient because they didn't use a separate contract document. The witness also testified that that separate contract document is nowhere in the record. I'm trying to confirm that when the settlement agreement says that they're going to continue to provide proper enrollment documentation, which was an issue in this case, what that means, okay? And I can't determine what that means. What's
Understood.
proper
Thank
enrollment
you.
documentation? So I'm trying to help the witness out because he says they've corrected the issue after November 14. I know there are complaints after November 14. I don't know from any testimony in this case that the problem was taken care of. They started using a separate contract document and CAD was satisfied. I don't know that. That testimony is not in the record.
Understood.
There are CAD complaints in the record, CAD files in the record after that date. And so if we look at one of those, you should see that the documentation that was provided for those.
So for example, I am looking at complaint 621348864. Again, that's 621348864. And it was filed in June. I'm sorry. Yes, June 25th, 2021, closed July 28th, 2021. And if you go to the CAD letter in the file.
Yeah, could you tell me what was the date you sent me the exhibits?
Sure.
You have that?
These are part of the Karen Robinson's exhibit. The date I sent these
No,
was,
I've found it, I think.
okay. Exhibit folder
26.
26, yes. And it's the first, I just clicked on the first file there at the top to see what date that was. And I believe that this is in the time period. And then if you scroll down to the CAD letter, it says it is my decision that your enrollment was valid and that Statewise Energy will not pursue the ETF as goodwill gesture.
Not my question.
Oh, okay.
Okay, I've pulled that up and I see a contract summary.
Mm-hmm.
I see a notice of cancellation. No. What is this?
So there's a there's the copy.
It says
of
contract. It's written over with something, but it says electricity agreement details. Is that what that says?
So are you on page 12 of 41? Yes. Yes, it is hard. It says, yes, electricity agreement details.
Electricity agreement details, and it looks an awful lot like the contract summary, right? And then the second page is where they sign.
Sure line, and then the term and conditions follow.
Okay, but do you see, by signing below, you agree to purchase natural gas and or electricity supply from Statewise Energy Maryland, LLC. You acknowledge and confirm that you have read the agreement. What's the agreement, do you know?
So I believe that the agreement would be the terms and conditions that follow. So this is a signed contract summary. But I think that this one is different than what we had seen in other CAD files, because if you continue to scroll down, you'll see again a different, separate but similar, well, I think they're pretty similar looking, contract
What page
summary
of the
form.
41 pages?
That's that would be page 24. So it's a copy of the summary which they signed, but it doesn't have a signature. And it has 2 notice of cancellations. But I also understand what you.
Okay.
I just think in the
So I
past we had
see that in
just.
this complaint that the difference between this one and the other ones is this electricity agreement details page. And then instead of the signature page simply starting with by signing below, it now has some information above it. I do see that this is different from earlier. Okay. Thank you.
Thank you.
So, Mr. Donnelly.
Yes, Your Honor.
What about the notice of cancellation? The notice of cancellation forms always were blank in a lot of the complaints. And at page 23 of your testimony, line 9, you testified that the inadvertent omission of pre-populating a date into the form was simply an oversight and unintentional. Was the notice of cancellation ever populated with either a data receipt or data cancellation 3 days after that date?
No, Your Honor, it was corrected after it was brought to our attention.
Yeah, that was my question. Was the notice of cancellation ever populated with, it was, when?
Oh, sorry, you're asking at which point did we start populating it?
Yes.
It would have been on and after the November 2020 date as we worked with our IT department, so I can't give you an exact date.
Okay, so the notice of cancellation pre-populated with those dates is part of the proper enrollment documentation under the settlement agreement?
Yes, Your Honor, that's part of the proper enrollment documentation that has been agreed to as part of the settlement agreement.
Okay. And then under section 3, paragraph D of the settlement agreement, (i), SWE agrees that the 7 customers who filed Consumer Affairs Division CAD complaints and any other customers who complained to SWE directly, internal complaints, in either case during the time period in the case, that the person who enrolled was not authorized, i.e. not the customer of record, will have their enrollments canceled, any early termination fee, ETF waived, and re-rates will be processed. With respect to the 7 customers who filed CAD complaints, haven't these customers already had their enrollments canceled and their ETF fees waived?
And they have been re-rated as well, Your Honor.
Okay, so this settlement term is meaningless, correct?
The settlement term is in relation to not just the CAD customers, but also internal complaints, which we're completing our review of those in relation to the settlement. So we have to go through a process of reviewing our internal complaints that we receive from consumers and identify ones that fall into this category and then address them accordingly in accordance with the settlement terms.
Okay, but under the settlement, staff will never know about those, correct? The settlement doesn't provide for a reporting of that information to staff, does it?
I believe it does not.
And pursuant to the settlement agreement, SWE is going to submit a compliance plan for staff approval, and you testified in your testimony in support of settlement, which has been entered into the record as Statewise Exhibit 2, that Statewise has prepared and submitted a compliance plan to staff, which you said upon information and belief they have approved. Is that your
That's correct.
testimony?
Yes,
Okay.
Your Honor.
What if staff never approves the compliance plan? Do you know what happens?
My understanding is if we don't come to an agreement on a compliance plan, then Statewise would still continue its voluntary position of not providing door-to-door and telemarketing services to customers until such time that we do agree to a compliance plan.
So under the settlement agreement, staff could refuse to ever approve your compliance plan and you would never market new customers in Maryland. Is that
I'm not expecting
If
that
I
to
could
happen.
interrupt, this is Peter Wilson. Staff has approved.
I'm not sure you can, Mr. Wilson. I will let
But
you
it
speak.
has been approved, so this is your.
It has been?
Yes, it has, Your Honor.
Your witness testified that he's never seen it.
I don't think he testified that he never saw it. But perhaps he had. I don't believe that was his testimony. I thought he didn't know exactly whether it had been approved or not.
He hadn't reviewed it.
Well,
Mr. Mosier, we can bring Mr. Mosier back.
I don't recall if I've seen this document or not.
The compliance plan.
Correct.
Okay, and that was your testimony earlier, correct?
I believe so. If I had to guess, I think I've seen it, but I've seen so many documents in this and other cases that they're at this point kind of blurring together.
Okay, Mr. Wilson, I think I was clear on what his testimony was.
well, yes, you may have been, but I can tell you it was circulated to Mr. Mosier, and it was approved by staff.
Is that information in the record? Other than through you, Mr. Wilson?
No, it's not.
Okay, thank you. Mr. Donnelly.
Yes, Your Honor.
Back to the settlement agreement. Statewise agrees to retrain and retest every in-person and telemarketing sale agent on compliance with Maryland marketing regulations and Statewise's health and safety plan prior to commencement of any marketing to new residential customers in Maryland. What does this mean?
Sorry, can you just reference the section number in the settlement again, Your Honor?
Sure.
Just so I'm looking at it at the same time.
Yeah.
I know it was mentioned before, but I lost track of what section it was in.
It's under Section G, allegations of misrepresentation. It's 3 little I.
Right. Okay. I have it here.
It will retrain each and yes, that's what it says. That it will retrain each and retest every in-person and telemarketing sales agent on compliance with Maryland marketing regulations and SWE's health and safety plan prior to commencement of any marketing to new residential customers in Maryland. Can you elaborate on what that provision is?
Yes, the provision is that upon obviously formal approval of the settlement and being able to recommence sales in Maryland, we would engage in retraining all of the sales representatives. And when we say retest, is we require them to not only complete a training session, but also a test and achieve at least an 80% or above on that, which has questions that are asked in relation to Maryland regulations for door-to-door sales and regulations under COMAR. We are going to be adjusting that training materials for retraining to address all of the concerns raised by staff and addressed not just in the settlement, but also in the compliance plan. For example, in properly identifying themselves upon approaching the customer's house, providing a business card, providing the sales pitch to the customer, waiting for the customer to identify whether they wish to proceed and are interested in the product offering, ensuring that they're not asking for the customer's utility bill until such time the customer's agreed to proceed. So those are some of the areas that will be adjusted on the training materials as part of the compliance plan and the retraining with all of the sales representatives.
Okay, what is SWE's health and safety plan?
Oh, sorry, yes, my fault, Your Honor. Health and safety plan is just in relation to specific COVID situation as it pertains right now. So our platform allows for a touchless process, and also the retraining would remind the sales representatives of their obligation as far as social distancing and mask wearing, et cetera, based on the current health regulations within the state at the time of us re-entering into the market.
Okay. Ms. Robinson, I see that you are still with us.
Yes, Your Honor.
Did you hear the case number that Ms. Moriarty referenced?
Yes.
Do you have that in front of you?
Yes.
Okay. So did you see the page, I think it was 13 and 14 of that PDF, or however you're opening it?
Yes, I have it open.
Okay, and it was my understanding from the testimony that this electricity agreement details 2-page document is what is new, and that Statewise started sending after November 14, 2020 as its separate contract document. Did you hear that testimony?
Yes.
Okay, and so I want to understand whether CAD's position is that yes, this electricity agreement details 2 pages is the separate contract document that CAD was looking for.
It's the signature page that I had submitted as a exhibit. Prior to this one, it was different variation, but the adjustments and the modification they made to the signature page, CAD decided that it met the minimum requirements for a contract. It's not titled a contract. It is a signature page. It's not the actual contract of the I-sign form. It's my understanding that the information was taken from the I-sign form and added to the signature page that's provided to the investigator. Because it meets the minimum contract requirements, CAD started accepting it as a valid contract.
Okay, so if Statewise sends out exactly what you see in this complaint, which is, let's just make sure there's nothing else, a document entitled Electricity Agreement Details, which is reflected on pages 13 and 14 of this file, along with, I guess, what follows it, which is terms and conditions. That goes through page 20. A notice of cancellation, the one I see here still has, it has a data receipt populated, but it doesn't have the data cancellation populated. But there was testimony that that's going to happen.
Now the electricity agreement detail that you're talking about was
Yes.
put in two pages.
Yes.
We consider the electricity agreement details on the page 1 is actually the contract summary that's required. The page 2 we have accepted it as their contract meeting the minimum COMAR requirement, although it's not entitled to be a contract. It's my understanding that it's taken from the I-sign document that the customer reviews and sign. We don't get that actual document, but the information is taken off that document. Because in the beginning, we was just getting a signature page that wasn't meeting, the COMAR requirement. with the contract summary. But to answer your question directly, CAD has started accepting that page 2 as the supplier contract, although it's not the actual document from the I-sign form that the customer reviews and sign off on.
Do you know what the customer reviews and signs off on?
No, we haven't actually ever gotten the actual document, but the information on that page 2, includes the information that's on that I-sign document that the customer signed.
Billing name, service address, electricity price and term, PEPCO account number, customer awareness, and residential consumers' rights to cancellation. And then by
Yes.
signing below. That's what you're considering a contract now?
Yes, that's what we have been now, accepting it as the contract without actually seeing the actual I-sign document. But that is what's been provided, and that's what we accept because it has all of the minimum information that meets the contract requirement, such as the billing name, the service address, the terms and condition, and those other information that you mentioned, the customer awareness, the rescind statement, the cancellation, and CAD's position is, of course, we would prefer to see the actual I-sign document, but it's my understanding that that can't be produced. So we have accepted the information.
It's your understanding that it can't be produced, you said?
We have asked for it on numerous times, but what we get is the signature page from the I-sign document with SWE adding the top portion of it to meet the minimum requirement of a contract, along with the other statements and to conclude the rescind statement and the cancellation. But prior to that, when we wasn't accepting it, it just started with by signing below with the signature. And I believe that was in my exhibit, the 3 variations that was being used. So this one is the final change that we have now start accepting.
But you don't know what the customer receives when they receive a copy of their signed agreement.
No, we don't. But the document that's been presented has been accepted as the contract with the e-sign signature.
Okay.
And it's my understanding this is what they're providing to the customer.
So they basically took the contract summary, gave it a different title, and then added billing name, service address, electricity price and term, PEPCO account number, in this case it's PEPCO, added that customer awareness block and the notice of cancellation near the signature. That was the change they made.
Yes,
To come up with a separate contract document.
yes, that's my understanding.
Okay. Do you know, and if you don't, it's fine, but the terms and conditions that follow it are there's certainly a lot more language than
Yes.
the details which are being considered the contract.
Mm-hmm.
Do you know if there are any provisions in the terms and conditions that aren't in what is now being considered the contract?
Well, the terms and conditions is summarized in the contract summary. And it includes the information from the terms and conditions to include the overage, information that
Right.
wasn't previously there, but, has been, included.
Thank you, Ms. Robinson.
Mhm.
Mr. Wilson, I wanted to talk to you a little bit about the settlement agreement, if I could.
Yes, Your Honor.
So under section 4, staff and OPC obligations, A states that staff and OPC agree that the Commission's approval of this settlement shall cause a dismissal of the complaint and amended complaint and all claims and allegations in case number 9661 with prejudice.
That's what it says.
Okay, so if I go back up to the top though, section 3, paragraph A, SWE agrees that within 30 days after the PULJ recommends approval of this settlement, SWE will deposit $150,000 into the Phillips Light LLP escrow account. Are you familiar with the manner in which proposed orders become final orders?
I believe they become final orders when the commission either fails to act on them after 30 days or if they specifically approve them.
Okay, so in this case, if there was a proposed order that approved the settlement and nothing happened after 30 days, that would be considered commission approval of the settlement. The complaint, an amended complaint, would be automatically dismissed with prejudice. But back up to A, what if SWE didn't deposit that $150,000 into the account?
Well,
the settlement agreement doesn't provide for any verification of that. Staff doesn't indicate it's going to verify that money's there prior to basically the order becoming final by virtue of statute, right? So are we faced with the possibility that the agreement could be approved, the complaint dismissed, and the money's not there?
within 30 days, perhaps that's true, but it would be a continuing obligation on behalf of the company, and they would be in default of the settlement agreement if they didn't pay it within 30 days of approval.
Okay, and then so someone on behalf of the commission could sue them in court under the settlement agreement.
Or the commission could revoke their license to do business in this state.
Okay, but in any event, the complaint and amended complaint would be
penalties.
dismissed with prejudice at that point.
It says shall cause a dismissal. I don't know if that's
The approval of the settlement.
yes, yes. The underlying claims and allegations would be dismissed.
Okay. And the commission's approval of the settlement, which again, we said could happen automatically after 30 days, shall operate as a release of SWE from any and all enforcement actions that staff and OPC may have arising out of SWE's activities in Maryland that are at issue in case number 9661. Do you see where I'm going with this?
Yeah, I think I do, and I think it's the intention is that those
aren't SWE's activities in Maryland that are at issue in this case, it's door-to-door sales? Are you not releasing them from all enforcement actions that could be brought based on their door-to-door sales in Maryland after this point?
I don't believe that's the intention here, no.
Okay.
Anything that would occur after the cases that are subject to this case would be subject to enforcement if there are violations after this case.
I'm glad you find that clear out of B, because I do not.
Your Honor, if I may, this is Tom Puckner. I apologize to jump in, but I think if you look at the last sentence of C,
It conflicts, right? Is that what you're going to tell me? I'm going to
Well,
get the
I think-
information that I want out of the last sentence in C, and I'm saying that's great. I don't think a internal conflict takes care of the issue. I find an ambiguity in B that I'm not, as a lawyer, happy with being taken care of with a sentence in the next paragraph. But maybe that's
I see your point.
okay. Does anyone have, Mr. Wilson, you wanted to be heard earlier. Do you still want to be heard?
No, Your Honor, I think I was heard.
Okay. And does anyone else want to be heard at this point? Okay. Hearing nothing. Thank you, everyone. We are adjourned. We can go off the record, Mr. Court Reporter.
We're off the record, Your Honor. Thank you.
Thank you. Have a good day, everyone.
Thank you, Your Honor. Healthy and happy holiday all.